Please get ready for a dictation of part 2 of a matter on Central Bureau of Investigation taken from Wikipedia. 5 seconds. Start. Guwahati High Court had given a verdict on 6 November 2013 that CBI is unconstitutional and does not hold a legal status. However, the Supreme Court of India stayed this verdict when challenged by the central government, and next hearing on this is fixed on 6 December 2013. Some legal experts believe that the ultimate solution for Indian government is to formulate a law for CBI as sooner or later the Supreme Court may hold the constitution of CBI unconstitutional. Demanding independent investigations, the CBI said that although it deferred to the government's authority in non-corruption cases, the agency felt that sufficient financial and administrative powers were required by the director, including a minimum 3-year tenure to ensure functional autonomy. As such, it is necessary that the director CBI should be vested with ex officio powers of the Secretary to the Government of India, reporting directly to the Minister without having to go through the DOPT, the agency said, adding that financial powers were not enough and it wanted a separate budget allocation. Some form of autonomy has been granted by the Supreme Court of India to CBI when it held that CBI can prosecute senior bureaucrats without central government's permission. Indian Supreme Court also held that Section 6A of Delhi Special Police Establishment Act is unconstitutional. The legal powers of investigation of the CBI are derived from the Delhi Special Police Establishment Act 1946, which confers powers, duties, privileges, and liabilities on the Delhi Special Police Establishment and officers of the Union Territories. The central government may extend to any area except Union Territories the powers and jurisdiction of the CBI for investigation, subject to the consent of the government of the concerned state. Members of the CBI at or above the rank of sub-inspector may be considered officers in charge of police stations. Under the Act, the CBI can investigate only with notification by the central government. The CBI was originally constituted under the Delhi Special Police Establishment Act to operate within the territory of Delhi. As policing and law is a subject that falls within state powers under the structure of Indian federalism, the CBI needs prior consent from other state governments in order to conduct investigations within their territory. This consent can be in the form of a general consent under Section 6 of the Delhi Special Police Establishment Act, which remains in operation for all investigations until it is revoked, or alternatively, a specific consent authorizing investigations in individual cases. Once consent is granted, the CBI can investigate economic, corruption, and special crimes, including national security, drugs and narcotics, etc. Most Indian states had granted general consent to the CBI to investigate within their territory. However, as of 2020, several states have withdrawn their general consent for the CBI to operate and require a special consent to be granted on a case-to-case basis. In November 2018, Andhra Pradesh and West Bengal governments withdrew general consents for the CBI to investigate and accused the central government of using federal agencies to destabilize state politics. Andhra Pradesh restored general consent in 2001 In January 2019, Chhattisgarh also withdrew general consent to the CBI. In July 2020, Rajasthan withdrew general consent to the CBI. In October 2020, Maharashtra withdrew general consent to the CBI. In November 2020, Kerala, Jharkhand, and Punjab withdrew general consent to the CBI. Tripura and Mizoram had previously withdrawn general consent to the CBI as well. Currently, therefore, 9 states require prior consent before the CBI can investigate crimes in their territory. Stop.